Today's episode of Lone Star Lawyers on the Varsity Podcast Network is brought to you by Varsity Search. Varsity Search builds great teams by connecting lawyers in Texas with career opportunities at small and boutique law firms. So if you're thinking of making a move or your law firm is looking to hire, please go to varsitysearch.com and book a time to visit right into my calendar. Varsity Search, building great teams. Hey everyone, Daniel Hare back with you on Lone Star Lawyers. This is going to be a different type of episode today, mainly because it's been a big week in the sports law world, and that is an area that I have a specific level of interest and also an area that I teach in. And so I wanted to take a little bit of time and dive into the NCAA Supreme Court case from this past week, where they lost 9-0 on their amateurism and antitrust issues, and then also talk about the name, image, and likeness issue, which is really coming to a head on July 1st, where state laws are coming into effect and are allowing for their athletes to monetize their name, image, and likeness without jeopardizing NCAA eligibility, and waiting to see what the NCAA is going to do about that. So wanted to dive into those issues, and Stephanie Grace is going to join us. Stephanie has been on campus working as NCAA compliance director and assistant athletic director for compliance. She's been at the NCAA National Office for 7 years, working in the academic and membership affairs unit there. And then she's also now doing consulting for colleges and athletic departments. She's been 20 years in intercollegiate athletics in one way or another, was a student athlete herself. So a great person to have a conversation with about the goings on with the court case, and then NIL. She's also a lawyer. And so excited to have Stephanie Grace join us on today's episode. So if sports law is not your thing and you want to check out and come back next week, completely understand. No worries. But if it is interesting to you or you're not quite sure, I hope you'll stick around, listen to it, because we have some fun, and sports law is always super interesting. Also, I should note, we recorded this as a live webinar, and so that's what you're going to hear is the audio from that live webinar. So it may sound a little different than our normal episodes, and that's the reason why. Thanks for being here. Let's hop into the episode with Stephanie Grace on today's special sports law edition of Lone Star Lawyers. It's great to see you. We can start being sports law nerds and dissecting a Supreme Court case. This is awesome.
Yeah, we've never stopped being sports law nerds.
No,
hopefully.
No, not really.
But this week is a big week to do that. So.
I mean, this week, this year, like it's funny because I was looking at some of the cases that came out yesterday or the day before even, and when I teach sports law, I teach some of the stuff around participation and procedural due process in schools and stuff. And so the cheerleader case was on my radar too, right? So that's another one that I'll be teaching this fall that adds to the case, to the case law around that issue.
Yeah, I think that'll certainly have some really interesting implications too in college sports, not just in high school sports, but
for sure.
How much does that free speech right extend to extracurriculars, if we can even call them that anymore? So yeah, I thought that was a really interesting holding as well.
Yeah. So I haven't read the case in detail yet, like I have with this one, but the NCAA one, but and then there was another case that I felt like was going to have to go into my class this fall also. So I'll have to go back and look what the site was for it. But yeah, it's just been a crazy year and a crazy few weeks for this stuff. And then the NIL on top of it, which is connected, but not exactly the same. So
right. Yeah. Yeah. And how long have we been talking about NIL? And now it seems we're at this point where July 1st is right around the corner. And here we are still talking about NIL and what's going to happen versus what has happened.
Yeah, well, and as we were setting up to start this today, I saw the Kentucky governor was about to issue an executive order, basically just mandating that their schools were all going to allow it. And I didn't go back to look. I don't know if they were one of the 19 or one of the that had delayed starts or that had just bills that hadn't got to his desk yet. I don't know where they were in the process. I just knew they weren't one of the 6. So
right.
They're 7.
Yeah.
Just all of a sudden by executive order.
Right. Yeah. Definitely starting to see movement in Oregon too. I think I'm not sure what the outcome was in Oregon, but I know they made some movement earlier this week as well. So it's not just really limited to those SEC states and New Mexico anymore. It's starting to go across the board here as we get closer to the first.
Yeah. Oh, man. So, well, as we start, and for people maybe that listen to this later or as they jump in and whatever, but I'd love for people to hear briefly about you and your background and who you are and what you do, and give people a context for our conversation.
Yeah, absolutely. So I'm Stephanie Grace, and I have been working in intercollegiate athletics for over 20 years now, which is ridiculous when I hear it out loud.
Yeah.
My first job as a coach actually was in 1999. So quite a little bit of time that I've spent in and around this industry. So currently I'm a senior associate with Brown Athletics Consulting, which is a consulting firm that's based out of Kansas City. I'm here in Kaiser, West Virginia, a very small town in the eastern panhandle of West Virginia. Yeah. Which is kind of interesting, right? Because Alston, as we talk about this case, was a football player at West Virginia University. So while West Virginia doesn't make news very often, not related to our COVID response, a lot of this case has West Virginia ties to it. So it's been a little bit interesting to be here and also to see the chair of the Division I Council be the athletic director from West Virginia University now as he transitions into that. So a little more West Virginia in the spotlight. But I started my career as a coach, like I mentioned, in the sport of rowing, and then transitioned into administrative work. And so I've been working in compliance and student athlete services now for quite some time on a couple different campuses, including Western Oregon, Division II, where we, of course, work together, but Division I campuses as well. Most recently, I was at University of Washington in their compliance office. And before that, spent 7 years at the NCAA national office within academic and membership affairs, which is one of the 3 departments that comprise the regulatory affairs team there. So a little bit of campus experience, a little bit of national office experience, and now a little bit on the consulting side, really, reaching out to all kinds of institutions, NCAA and JCAA, and getting to interact with a lot of different administrators and student athletes on that path.
Awesome. That's great. And yeah, the breadth and depth of your experience, I think, is unique and makes you super qualified to have this conversation. And so I will rely more on you than on me for sure today, as is always the case as we've worked together at different times. And for me, I'm Daniel Hare, and I spent about 10 years working in college athletics in various roles, development, compliance as an athletic director. And then more recently, over the last few years, have transitioned more into the legal world in law firms and in law school education, as well as continuing to teach sports law, coach sports law students in competitions, write and podcast and do a bunch of different things. So I've been able to keep my toe in the water as much as possible while doing other things as well. And but certainly as we were saying before, the last few weeks building up to this decision in Alston was an important one. And then also the NIL stuff, which we'll talk about as well. So let's start with the case. And since we have, I feel like I did a couple of radio deals the last few days, which are so fast, and like 2-3 minute hits, you got to like explain a Supreme Court case, which is good training. It really is. Like, it's good to kind of really narrow down and kind of try to explain it. But I do want to take advantage of the time that we have to go a little deeper. But to start, let's just I'm curious what your takeaways were. Kind of what are your big picture takeaways? And then let's dive into some more of the nitty gritty.
Yeah, absolutely. So let me preface this by saying that I'm in no way, shape, or form an antitrust expert by any means. But I think, looking at the key takeaways as someone from an intercollegiate athletics lens, someone, maybe sitting in a compliance office right now, and what are they thinking versus, oh my gosh, it's actually happening. We've got to move now.
Right.
I think there's a couple things that really stood out from this decision. And the first one being that what we're talking about in this decision, right, is not, as I think some folks have characterized it on Twitter and other places, this is not the death of amateurism, by any means. I think one of the first takeaways that we need to think about here is, what was the court actually talking about? What was the question that was presented to the court? And the question presented was specifically having to do with enhanced education-related benefits for a class of Division I football, FBS, specifically student athletes, and Division I basketball student athlete, men's and women's. So while I do think this case has really far-reaching implications for the topic of amateurism, I do not think in any way, shape, or form that means that we no longer have a collegiate amateur sports model. However, major shifts, right, are coming in that model. So basically, I think what the court told us first and foremost in a unanimous decision, which is not something that you see from a court this divided, right? So that was kind of a surprise, at least for me. I wasn't expecting this to be a 9-0 decision, but the court's telling us that they are not going to create, at least from the judicial perspective, an antitrust exemption for the NCAA. So they're saying, right, NCAA, if you're going to conduct a business in the United States, you're going to conduct your business just like everybody else and be subject to antitrust scrutiny. The exception that perhaps you believed existed based on prior case law, I think the court told us, as another one of the key takeaways, which I'll talk about in a minute, doesn't really exist for you. So if you want that, then maybe Congress is the appropriate avenue, which wasn't good news, right, for the NCAA, the association and its member schools, because they've approached Congress, I think, several times for that antitrust exemption. And so far, the answer has been, no, we're not willing to extend that legislatively either. So I certainly think we'll see some continued movement and lobbying in that area. But the court has held here that the NCAA is not subject to an antitrust exemption based on this principle of amateurism, and that they will be kind of ordinary scrutiny for them under the Sherman Act, just like any other business in the United States. I know that you appreciated the language in Justice Kavanaugh's concurrence. And I'm gonna read this one so I get it right. But the language that said law firms cannot conspire to cabin lawyers' salaries in the name of providing legal services out of the love of the law. Because we hear that often, right? And I think that it's language that we who have worked in college athletics, and we hear student athletes use the language too, that they play for the love of the game. And I don't think any of this invalidates that, but I do think it recognizes that student athletes do have certain rights as a collective labor market under antitrust law in this country, and that there is not an exception, at least that's going to be judicially created for the NCAA to treat them differently. So that was kind of my first big takeaway from the case, really the holding in and of itself.
Yeah. I mean, I think it's important to recognize that, as you say, I mean, for really ever since Board of Regents was decided back in 1984, which is, gosh, been 37 years in between Supreme Court cases on this topic. Basically where the NCAA lost, let's not forget, they lost and created the television dynamics that we have today, and really created college sports the way we have it today at the high end in the revenue sports and all of that. So, but it's been that long. And the thing that the NCAA had clung to in that case, some of the language that Justice Stevens wrote at the time, sort of giving deference, recognizing the NCAA's unique role in protecting collegiate athletics, amateur athletics. That was the language that the NCAA has clung to for 37 years as essentially trying to argue for a baseball-like judicial exemption from antitrust law. And they basically, since we haven't had a Supreme Court case on it, we haven't had anyone, we haven't had a Supreme Court ruling since. So we haven't heard from the Supreme Court since then about that. We've heard from district courts and courts of appeals, which do matter, obviously. But so it was interesting to really, I think, finally cut the cord to that language officially, that it was specifically in the opinion, that was dicta. That does not hold here. That's not what we believe the court was saying, or Justice Stevens was saying. And so, yeah, I mean, I think that is a huge, huge deal because as the court talked about, as Justice Gorsuch wrote, that so much of what this case was about wasn't disputed. I mean, there weren't that many factual disputes. Like, there's not a dispute that the NCAA has a controlling monopsony over this market. There wasn't a dispute that they are fixing the price of labor in the way that they are. And usually those can be factual disputes at trial. And those aren't for dispute. Really, it's all about whether there are these pro-competitive reasons for these restrictions and then whether or not those restrictions are, appropriately and not unreasonably restraining trade. So it's to go through that analysis now, and we know going forward that the NCAA is going to be subject to that, like you said. It just, I think, gives the NCAA a whole new. They have to rethink everything in the way that they go through litigation from here, and there will be more litigation, obviously. And so, but they have to. I guess they could. I just can't imagine them continuing to try to argue what they have been. I mean, they have to have a different strategy going forward, don't you think?
Yeah, I think that's the key takeaway if I'm thinking of this as a legal practitioner, that the Board of Regents decision from 1984, which, like you said, there's been litigation in the meantime that hasn't made its way up to the Supreme Court level, but certainly in the circuits and more than one circuit, 3 or 4 circuits have weighed in on this issue or similar issues having to do with what the NCAA and its member schools can and cannot do when it comes to controlling sections of the market. So to me, if I'm looking at it from that perspective and that lens as a legal practitioner, that's the biggest takeaway, is that the Captain America vibranium shield that the NCAA has been able to wield since 1984 is really, really best case scenario weakened, worst case scenario for them, just it is what it is. It's dicta. It's not controlling. And I thought it was interesting the way that Justice Gorsuch worded that in the majority opinion. And he didn't go quite so far as to call it dicta, but called it just about everything. I think if you looked maybe at Black's Law Dictionary, you might look at the definition of dicta as, non-binding language in a case and see that that's how he described it. But then you have, of course, Kavanaugh saying, oh yeah, it's dicta, no question.
Right.
If you're waiting for that hammer to drop in actual words, you found it there. But that I think is going to be really interesting. And let's remember that there are other pending cases right now where judges are already asking the attorneys in those cases to say, well, how does this decision impact? And we even saw today, I saw just minutes before we jumped on here, that Judge Wilkin, again, who was the district court judge in Alston, has denied a motion to dismiss the House case as well. So if I'm a plaintiff's attorney right now, I am looking at this Alston decision and just cutting and pasting and adapting language to every brief that I write from now on if I'm challenging the NCAA in federal court, because I think they certainly have been armed with not only the loss, so to speak, of the shield of Board of Regents, but I think, Kavanaugh, especially in the concurrence, which we know isn't a controlling opinion, but still, I think he's done plaintiff's attorney is quite a big favor here in handing them a whole lot of language that they're going to be able to find useful in cases that are currently pending and in cases that will be pending.
Yeah. And also, just as a reminder for folks, I mean, at the trial court level and at the Court of Appeals level, I mean, the plaintiffs in this case did bring a much broader action. And it was only when they got to the Supreme Court that they carved out and decided not to appeal on the places where they lost. So that's why in the majority opinion, you're only hearing Justice Gorsuch talk about, as you mentioned before, these educationally related benefits and not anything else, because that was the only thing that came up on appeal. The athletes chose not to, for strategic reasons, to make that appeal. That it seems like that paid off for them to get a very clean ruling on the Board of Regents stuff, the antitrust application, the amateurism stuff, which I was thinking why they did it, and to move forward now to use this decision to influence the next round of litigation as opposed to muddy the waters and make the court essentially decide a case about whether or not we're going to have amateur unpaid athletics anymore or not. I think they probably made that choice that that was a risk that they might not be able to prevail on at this point. But I don't know it's obviously hard to know when you just get this narrow ruling on the 9-0, you get Kavanaugh concurring with the hammer. And what really almost, I was talking to another friend of mine who is in an athletic department and a lawyer as well. And we were talking about it, and he was saying the Kavanaugh opinion almost read more like a blog post or a rant, from a judge against it, as opposed to because there wasn't a ton. I mean, it was only 4 or so pages. It wasn't super substantive, but which is why probably more didn't sign on. Which is, I think we can talk about what the impact or takeaway is from the fact that it was just Kavanaugh and no one else signing on to his concurrence. But it seemed more very personal to him than than legal. But it does send a signal, as you mentioned, to the plaintiffs' lawyers and to the NCAA about, I mean, to me, it's sort of you need to figure this out either through your own deliberative process or through Congress, because I don't think you want to be coming back here is what I kind of took from it. I don't know.
Yeah, that was definitely a huge proceed with caution sign, I think, coming from Justice Kavanaugh. And yeah, I think you look back at the strategy that the plaintiffs' attorneys took in this case, and Kessler and his team, and now as a look back, when you have a unanimous 9-0 decision, you think, well, maybe they could have pushed a little bit more and not limited the question so narrowly. But I do think, to your point, that probably is and was the right strategy at this point, because cases like this are so fact specific. And so I think that's right. I think they calculated that risk. Of course they did. That's their job. And said, here's the question that we want to present to the court. And, again, I think you're right in that Kavanaugh was the lone concurrence here. And so there is something to be said. And I think that's something that President Emmert from the NCAA really made sure to, emphasize when he spoke to the media after the decision came out, is that we're talking about one justice here who has this opinion. And, just as an aside, we all know that Kavanaugh loves his sports metaphors and, will do anything to put a sports metaphor into the case. So he must have just been really, really, really happy to have his clerks writing this decision specifically about football and basketball student athletes. Found a way to put a legal analogy in. So he kind of turned the tables there a little bit. But I do think there is merit to what the NCAA is saying there, certainly, that this is a concurrence. This is not the majority opinion. It is not binding. That won't stop plaintiffs' attorneys and plaintiffs from citing that language in cases. But I do think that's relevant for folks to think about, because I do think a lot of the media coverage has really centered around that language.
Of course.
So if you don't take the time, because it's the hammer, it's the firecracker language that everybody can take the snippet from and say, down goes the NCAA. But it's important to remember what it is and what it isn't, and what it isn't is any sort of controlling decision coming out of this case.
Yeah, it's as we've always, you learn in law school, it's persuasive authority, right? It's not controlling, but the other thing to sometimes when you get these concurrences like this, you will sometimes see in the majority opinion an acknowledgement of the concurrence and an addressing of the concurrence. You didn't see that here. The majority isn't saying Kavanaugh's off his rocker. We don't go that far.
Yeah,
they don't say that, and they could, and it was 9-0. So, I don't know. I think I would be. Yeah, I think you said it earlier. I mean, proceed with caution, I think is sort of the calmest, slowest way I would say it. I mean, I think otherwise the NCAA's got to take. I mean, I can just see like that. I mean, I get the PR defense of Kavanaugh's one justice. I hope internally that's not what they're rallying around. I mean, I think that's the wrong message to take away, is that it was one justice. So, but you're right. It was the wording that was most clippable and snippable, and it was what you would usually get from a Scalia or a Ginsburg. The fire and the saltiness and all of that. Which made for good, social media. But yeah, at the end of the day, it's not controlling. So, but Gorsuch's opinion, for as I would say, just sort of methodical and bland as it was, did basically go one by one through each of the NCAA's defenses and knock each one of them down relatively. I mean, cleanly, like didn't seem to wrestle that much with many of them.
Yeah, I think that's right. And I do think that the majority was very methodical and intentional about disassembling each one of the defenses and, letting, again, like we touched on before, letting the NCAA know that your business model doesn't exempt you from complying with federal antitrust law. So, I think that's a really good point, because it wasn't, the majority took great pains to do that. And to your point, didn't say, Kavanaugh's language may not be controlling now, but who knows what happens next, and who knows, how the circuits will find that persuasive when they ultimately see the legislation, like I said, that's already pending before them, whether it's in district court or at the circuit level now, or cases that plaintiffs' attorneys are preparing to file.
Yeah. Right. I mean, because you're right. I mean, I think you said it earlier, like these attorneys are going to cut and paste, right? So as soon as if the Ninth Circuit decides to adopt essentially a brief from a plaintiffs group that includes Kavanaugh's language, now it does become controlling over at least the Ninth Circuit. And that is very easy to do, especially in the Ninth Circuit, and especially as we've seen the way that these cases have gone up through Judge Wilkin and then the Ninth Circuit. So it wouldn't take, I think there's a pretty easy way to see a world in which not that long from now, his words are controlling, at least in some part of the country. So what do you think about just the practical impacts of the educational related benefits? Let's talk about just like the very specific practical, you're on a campus and now here are these things that are now available that weren't before, or however you might look at them.
Yeah, so I think the one big question that folks are going to have, and it's a pretty reasonable question, right, is what the heck is an education-related benefit? Now we can give these to our student athletes in essentially, an unlimited way, although the definition of the word unlimited certainly was something that was addressed at length in the briefs in this case. But what exactly does that mean? And so I think, have to go back to the district court's injunction and decision to say, we're talking about specific things here. We're not talking about an across the board. I loved the language in the majority opinion that Justice Gorsuch wrote, that this is, there still can be a no Lamborghini rule, because it's probably reasonable to assume that Lamborghinis necessarily aren't related to education. It's not a benefit related to education. But I think that's first and foremost the question that has to be answered is, are we going to get a definition of education-related benefits? I think it's likely that the NCAA will go back and seek clarification at the district court level, whether it's using the option that the district court told them they have, and to define what is an education-related benefit, and then having that kind of entered into the judicial decision so that we have more clarification. But I think that opens up a whole host of questions, right? And I do think that schools and conferences in the NCAA and the NCAA itself as an association have been preparing for this. There seems to be a conception, at least in some part of the public eye, that this decision was a big shock. And I don't think that's true. I think that there are lawyers all over the country working on behalf of the NCAA and member schools, and that have been preparing, as well as compliance departments that have been preparing for this decision, and probably expecting it to at least, give more latitude, if not as much latitude as it did, to education-related benefits. But, obviously I don't want to call it a doomsday scenario, but the question that always arises, right, when there's more flexibility that can be provided in any sort of benefits space, whether that's related to education or athletics performance or recruiting, is our schools going to take advantage of this? And is it going to be quote unquote unfair as they compete on the labor market for student athletes? And the answer is yes, they are going to take advantage of it.
1,000%.
Of course they are. That's always going to be the answer to that question, is anytime there's more flexibility there, we're going to find the limit of where that flexibility is. So I think it's an interesting question. What is an education-related benefit? I think it's easy to say maybe a Lamborghini isn't. But if I'm a sports management major, like I was in college, a trip to the Super Bowl, is that out of the question as an education-related benefit if that's something I want to pursue as a career path? Working in professional sports. So could my school provide that for me? A trip to the Galapagos Island, if I'm a biology major, is that something that's related to to education. One of the big sticking points, I think, in the NCAA's argument was that this decision would extend to paid internships. And so the scenario that was presented is that, well, paid internships are going to become the new kind of unlimited recruiting, free cash, free car. We're going to give a student athlete, maybe a high performing student athlete, a $50,000 internship to work at Nike for 2 weeks. So there's lots of questions that have to be answered on a factual basis, but I wouldn't be surprised to see the association go back and get some clarification on this issue. One, I think because it buys them a little more time to really kind of implement fully what this means. And two, because I think, if you're going to have a membership organization where there's contractual obligations in place, then there has to be some sort of indication about exactly what that means. And there are named things in the injunction. Musical instruments, I think, is one of them. Computers, things like that. I do think it's important to note too that schools already have fairly wide latitude to provide educational related expenses to some degree, but it would just really move that cap. I don't think the perception that schools are not doing this now within the rules that they have at current. I don't think that perception is correct.
Right. Yeah, no, I think that's right. And my mind went where yours went when it comes to the trips. Study abroad, study at the Super Bowl, study at the, those types of things, which I think I could stand up and make a pretty strong case for a lot of those things as being educationally related. Absolutely. And then, the other side of it being, when you're kind of in that like instruments and computers land, what counts as a computer? I mean, you could go cell phone to computer to 55-inch monitor to there's on the technology spectrum today, that's a fairly wide scope potentially. Again, maybe where you get clarification, but transportation, I do think matters. The Lamborghini rule is the extreme, obviously, but there's some place in there where getting kids to class certainly is a thing. And depending on your campus and how it's structured and how easy it is to navigate and whatever, so you can see, transportation type things being included and then others not. So yeah, trying to figure out where all those lines are. I think just, another on the list of the duties for the compliance office and all fun stuff.
I think one interesting question, and the court touched on it a little bit when they talked about, cash in terms of academic awards versus athletic awards. And let's not forget that there's a whole host of awards and benefits legislation in Division I that allows for certain things to be provided as part of the student athlete's athletic experience. So I wonder if we'll see conferences talking amongst themselves about, is any of that guidance for what might be a permissible academic related expense? If it's something that we provide on the athletic side, because we just said that it's incidental to participation. Well, what is incidental then to academic success or, even just pursuing academics? So I think it's going to be really interesting language that we'll see here coming out of whether we see, it in new NCAA rules or in the language of the injunction itself. I think, I thought that was a really, really interesting piece of this opinion because it said, hey, NCAA, you say all this is amateurism. The crux of it is not paying student athletes to play, yet you allow some of this on the athletic side. So, is there a compelling reason to limit things on the academic side? So I wonder if we'll be pulling some parallels between what's provided as incidental to participation as we decide what's incidental to academics.
Yeah, no, I agree. I thought that the point that or the section where the opinion kind of walks through the timeline of, we basically had free for all when college sports started in 1890 in the boat race at Harvard, Yale. And then you had, then there comes some organization along where, okay, now we're doing tuition, and then now we're doing room and board 10 years later. And then a few years later after that, we're doing full cost of attendance. And in between there, we're letting professionals that are in one sport play collegiately in another, and that's okay. And at each step along the way, essentially the argument that they're making is college sports has only gotten more popular, not less. And so to the point about, like you've got all these awards and benefits legislation that allows for so many of these athletic awards. It's on the one hand, it's sort of like the NCAA has tried to provide some of these things and adapt at times, but it also, every time they do, it hurts the overall argument, right? That the unpaid nature of the athletes are what drives consumer demand for the product. And so that just gets cut and cut and cut and cut. We just haven't seen any evidence of it. And then when you get to where Kavanaugh goes with it, which I appreciate, is basically his view seems to be, even if it were true, it's a circular logic. You can't create an illegal feature of your product, make that the product, and then use that to say that's why you can't do the thing that's legal. You can't, it's still illegal, which is the thing that you started to read earlier with the list of examples that he gave. And so that's going to be interesting to see when we get back to another court decision, how a Ninth Circuit or even trial court, Judge Wilkin or whoever else kind of addresses that line of argument. Because I thought that was where Gorsuch was really, we were so methodical earlier, just kind of going one step to the other, to the other, to the other, and just where's the evidence that the product is hurting because of this.
Yeah. And I do wonder, that's a really good point. And I do wonder sometimes how much public perception plays in here, because historically, and you're absolutely right, if you think about it and you look back, we've heard again and again from the member schools that make up the NCAA that providing more benefits to athletes, whether that's in the sense of, if you think back just a couple of years ago, the discussion about increasing scholarships to full cost of attendance versus just your grant and aid amount. So getting more education related expenses into an athletic scholarship, basically. Yeah. I think the assertion was that we heard that was going to destroy the amateurism model in college sports as we knew it. And I just wonder how many times, and I hate to characterize it this way, but how many times you can cry wolf that this is going to be the end of collegiate sports as we know it. And then you do the thing, right? Because it needs to be done, whether that's because of pending litigation or because it's just the right thing to do. In the eyes of the business model, you do the thing and then college sports only become more popular. So, it's difficult to imagine a world, and maybe I'm being naive here, but I do think it's difficult to imagine a world, especially coming out of COVID. We're still in the middle of a pandemic. So it's difficult to imagine a world where the demand for college sports on the consumer side is going to go down, despite what benefits student athletes may or may not be entitled to receive. So that's a really, really sticky situation to be in if you're a member school or a member conference that's responsible, right, for providing those benefits. It's just a really, really, really difficult and chaotic time to kind of have to make those decisions right now.
Yeah. And, as I've looked at it, I do think that there is a legitimate argument that you need to separate college sports from professional sports. Like, it is a unique product. And to that extent, you should have, a mechanism and rules in place to separate it so that it's not just another minor league sports, enterprise. But to me, what separates it is the college. Like, it's college, it's people care about their college and their university and their state and the pride that they have in it. And that kids are in school there. And so to me, like, I don't remember if it was in one of the two opinions or another comment on it, but simply, it may have been mentioned here, but, having students in good standing enrolled at the university, like that's, that separates it enough, to create college athletics. It's going out there and wearing University of Tennessee on your jersey means something different than wearing Tennessee Titans. It just does. And it's not the fact that they're not getting paid, as we've kind of seen over the years. But I actually think that's a good thing. It's actually a positive thing. And that the brands of these schools and of college athletics is so strong, and it's tied to that pride in our culture and our schools and where we went to school and where we grew up and all those things. Like, that's what drives it all. And so, at this point, it's maybe too late to try to turn onto that dime, but I don't know.
Yeah, no, it is certainly a difficult, and I think we're kind of on a precipice. I agree with you. I mean, to me, I'm an alum of the University of Tampa, where I was a student athlete. So to me, the Tampa Spartans are going to matter more than, other Tampa Bay teams, just because that's my affiliation, that's my college. And, we're talking about a Division II school, a private institution that, isn't by any means something that you're seeing on television every weekend for a football game. So I do think that certainly that is unique to college sports. And I do want to acknowledge too, there is great potential, I think, here for harm within college sports, because we are not just talking about football and basketball, though this was the class in this suit. You have to kind of reconcile that with the fact that it's going to be really hard now to have a pro-competitive justification to apply different rules to different sports. So we are probably looking at across the board. And what's that going to mean for sports that are not football and basketball? And that's one of the major arguments against extending additional benefits is we have a finite pool of money, we being the schools and the conferences. And so if we, in a sense, spend all our money on football and basketball student athletes and their compensation, then we harm others. And that's a really, really difficult argument to get around. It's really, really difficult when you're talking with those student athletes from the other 24 sports that aren't football and basketball, and understanding what the potential impacts are, going to be now there. So whether that's from an NIL perspective or an academic benefit perspective. And of course, I know we could talk about this for weeks as to what that means in terms of affecting women's sports differently, what that means for compliance for Title IX and other federal equity laws. And especially when we're talking about football and basketball, what that means in terms of racial diversity, and who is, going to benefit from the changes that are coming, and who might not be able to benefit from some of those changes. So when you look at it from making sure that we're continuing to move toward a more equitable lens, this isn't one issue. It isn't even one issue of the law. It's not just limited to antitrust law, but when we talk about benefits for student athletes, NIL, we get into all kinds of stuff, Title IX, tax law, labor law, private versus public institutions when it comes to labor law and those decisions. So, kudos to the attorneys that take this on and get paid to figure all that out, while the rest of us get to analyze what they're doing. But I think it is, a really, really interesting and really, really complex area that we're dealing with, and is as much as we love our affiliation and love to watch our teams on TV or love to go to live sporting events, to really process all of the things that happen behind the scenes, not just on campus, but in this ecosphere generally is quite staggering sometimes.
Mm-hmm. Yeah. No, and Justice Kavanaugh even mentions that in his concurrence, that he recognizes that this will raise other issues. You mentioned most of the ones that he mentioned. And so he acknowledges that, like those are issues that are going to come up, and it doesn't change the outcome of this case, because the justices are dealing with the very narrow antitrust decision on this particular case. But he said, kind of suggests that there are other mechanisms for dealing with these other issues. Congress is one, collective bargaining was another he mentioned. There were multiple ways that he's, basically like, yeah, I acknowledge that needs to probably happen, but to address a lot of the things that you're talking about. The other thing on the, kind of the budgets and where money comes from, I think it's interesting that the starting point for those conversations when, we're talking about like how will this impact all these, the other sports and everything, is there seems to be this like starting point of, either we're going to have to bring in more revenue or we're going to have to cut sports or, cut from like the non-revenue, whatever. It's interesting how there's never a conversation about, well, we could pay our football and basketball coaches less. Yeah. I mean, that pool of money is there. Like, we could not put 100 million into a new facility, and instead we could save 10 million of that and put it into whatever compensation we're going to do for the athlete. Like there's, especially at the level that we're talking about, right? Because we're not talking about Tampa and Western Oregon when we're talking about this. We're talking about, the top 60 FBS, essentially schools. And so it's like, if we're going to be serious about this and in the steps moving forward, it may mean a restructuring of the model that we're financially managing these sports with, because to address the other ripple effects that will come. And it can't just be like, oh, we got to assume that football coaches need to continue to make 10 million a year in this new world. Like maybe they don't. Maybe they don't. I don't know. I mean, that's going to be a tough change, but I mean, like, so anyway, well, we have maybe 10 or 15 minutes left, and I do want to talk NIL as well. And so as we're talking, June 24th, D1 Council met this week. I think last week we maybe thought they would try to move this week on something, but then it looked like it got kicked to Monday, maybe. I don't know if you have anything more updated than that from what I saw, but how are you feeling like things are progressing on the NIL front as July 1 is a week away? 6 states, maybe plus Kentucky, I guess now 7, going live with NIL. And here we go.
Yeah, well, I think we're certainly at the point where I don't know that there's any argument that the name, image, likeness stuff is happening, and that, whether it's state law that's going to be controlling here in a couple of days or NCAA rules that are going to be controlling in the states that don't have NIL legislation about to go into effect, that there's going to be massive change across the board. Even those states that don't have an NIL law that's going to take effect here July 1, is there really a realistic enforcement mechanism if you're in this untenable situation? If you're in a state that does have an NIL law that's going to conflict with NCAA rules, is that you're either going to have to violate your membership contract essentially with the NCAA, or you're violating state law. So take your pick, which one is it going to be? So, I think realistically, and from the, association perspective, my guess would be that there's not going to be a realistic enforcement mechanism or eligibility mechanism at this point to be able to enforce whatever NIL amateurism rules that are still in the manual by the time we get to July 1. So right. I think there is frustration with the lack of movement. I think the Justice Department's memo that came out several months ago that said, hold up, you might want to think about some antitrust issues with the prior administration. I think that really threw a wrench into things when, the Division I Council was about to maybe make some progress. My hope is, just kind of personally as an outside observer, that there will be an increased impetus for the NCAA, the bodies in the NCAA governance structure, and particularly in Division I, to be more proactive when it comes to dealing with these issues head on. And that's really easy for me to say as an outside observer and someone who's, not currently, in the membership, working in the membership. But I do think that there has been hesitation for a variety of reasons. And now we're kind of at this breaking point. I think we can learn a lot as fans and as folks that work around college sports generally. And I hope that we do learn a lot from the way that the NIL legislation, and I mean NCAA legislation or lack thereof, has progressed to this point to say that, maybe we need to look a little bit closer at issues that are coming before us, and that's hard to do, right? Because you've got pending litigation, you've got Congress weighing in, and so it is difficult to have a membership organization of this size that's able to come to some sort of consensus when you've got Division I schools across the board, from your, millions of dollars coming in to millions of dollars going out. So I wonder if NIL and the similar issues that are coming to light, or that where there needs to be change effectuated, I wonder if we will see more autonomy now going to the conferences. And we talked about that, and even in the Alston context, it's, conferences have pretty wide latitude to do what they want to do, as long as they're not price fixing with one another. So that's the tough part. It kind of brings to mind to me the Spider-Man meme where they're all just kind of pointing at each other. Right. To say, okay, it's your move. Who's gonna go first here? So it's, I think that ultimately everybody now is in agreement that allowing student athletes to manage and benefit from the use of their name, image, and likeness is a good thing. I know that the popular term now is just what guardrails we're going to put on that. I think the House case that's pending will be interesting. And then we saw the motion to dismiss denied today. So we're going to continue to talk about this from a legal perspective too. But I do think we're at the point where everybody is like, yeah, this is a good idea. Now, how do we implement it to still, maintain things that we need to maintain integrity in? Right.
Yeah. And it looked like at one time there was talk of a third-party administrator, and that has seemed to go down now and not being pursued any longer. And one of the things that, just practically that, you think about really the NIL stuff kind of starts with the O'Bannon lawsuit now, like 12 years ago, I think, when it was first filed. And the context of that, his image being in the sports video games, EA Sports video games, and in ESPN Classic, old UCLA game like replays, was really kind of the foundational purpose of that lawsuit. And now, when you kind of see where we've come with technology and with social media and with influencers, and I'm wondering your thoughts on the transition from that still kind of being mostly about football and men's basketball athletes to now the levels and numbers of athletes in all sports, men and women, that can really take advantage of the opportunities that exist right now. I don't think this is nearly as much and as important it is for the Trevor Lawrences of the world as it is maybe for, the UCLA gymnast who's got like 28,000 Instagram followers and is going to be able to, bring in some decent money while she's in college. I mean, talk about that a little bit.
Yeah, I do certainly think that that's absolutely right. The opportunities for student athletes to monetize their social media, for one, I think is the huge example, has exploded. And I think, we've seen that just, working in college athletics for the past even 10 years, the difference between, what a promotional activity is, what's permitted and what isn't permitted under NCAA rules. That legislation, when it was written, never contemplated the arena really that the student athletes are in today. And I don't mean the playing arena or, where they perform. I mean their social arena. And opportunity, just, built-in opportunities to monetize that are just built right into the platform, whether it's Instagram, YouTube, or TikTok, or whatever. So it's easier for all of us, I think, to monetize if we want to put the time and effort into what we're doing on the internet.
Click the link to donate. I'm
exactly.
This is free. No money.
Yeah, absolutely. And to sell products, that was one of the big categories of things that we saw, when I worked at the national office, is student athletes being entrepreneurs as well, whether it's producing their own music or producing their own clothing or, all kinds of different things that were really, really interesting in cases that you can, go on read about in the news about, what student athletes are doing in addition to their sport and in addition to their academics. We kind of live in a society where a side hustle is normal now, like that's everyone's expected to have
big
one.
economy. Yeah.
The opportunities are just, and I think that, is part of the common sense justification for updating name, image, and likeness rules to say, well, this is, it's getting to the point where it's kind of ridiculous. I have a 14-year-old nephew who could probably be making money on Instagram right now. Maybe he is. I don't know. I mean, he plays a sport. So, if he's able to do that and maintain his mental health at the same time, then I say more power to him. But it was interesting to see the kind of rules shift and change in the other divisions as well. Before you get into Division I, where of course there's probably going to be overall a collective, more of a collective ability to monetize there. But I think it's, we're dealing with rules like many rules, not just within the NCAA, but just generally rules and laws have to change and flex to reflect the society that they're meant to govern. And so I think that's especially true for NIL. And ultimately, I think it's a good thing, and I worked with student athletes directly when I worked at the NCAA, and I hear the arguments, and I am sensitive and understand that the arguments that if you have someone on your team that's making a lot of money, that's going to change the dynamic in the locker room or wherever. So there's going to be issues that maybe we're not thinking about on the front page when we talk about NIL. And it certainly will change the locker room dynamic if you have, a gymnast who's making thousands of dollars from her Instagram and other teammates are not. But I don't know anymore that that's a reason to put restraints on the students who have the ability to do that.
Yeah, no, I think that's right. And that entrepreneurship thing is absolutely right. I think I should stop and give credit to, I said it all started kind of with O'Bannon. That discredits Jeremy Bloom. I'd say Jeremy Bloom probably really started this at Colorado back in the 90s. So good for you, Jeremy, for getting the ball rolling or the ski down the hill or however we want to analogize that. The other thing about this, again, kind of focusing in on the non-football and basketball athletes is especially at the high end, the high level folks, they have the opportunities to go and make money professionally after college, the ones that are performing at the highest levels in football and men's basketball, especially, and in women's basketball now some too. But for so many others, the time that they're in college is their most marketable time. When it comes to their athletic ability anyway. I mean, that is like the prime earning years. And so, that's an exciting thing about this, whereas like it sort of seemed weird and unfair that the quarterback could be getting all these endorsements and monies and all that stuff, and he's not, and that's true. But also there's more upside to that person in the professional world than there is for the gymnast or for the swimmer or whatever else. And so I'm excited about that for all of our athletes that don't really have a professional route, which is almost all, to be honest, so that's going to be exciting.
I think the focus now needs to really shift. And I think it is shifting onto what sport services, athletic departments and colleges and even conferences are going to provide for student athletes to enable them to, if they want to take advantage of monetizing their ability, wherever that ability lies, that how can we best support them in that way, and whether it's, talking about smart financial decisions or really mental health, how is your mental health going to be affected if you're a student athlete who's spinning all of the plates, including potentially endorsements and things like that. So I do think that there has certainly been an increased focus, especially, and I give a lot of credit to the NCAA national office in that space and, the leadership development division that really is, trying to create, not necessarily NIL focus, but trying to create and is creating and implementing programs that are focusing more on student athlete mental health, the Sports Science Institute, and just developing those leadership abilities alongside everything else that the student athletes are doing. So there are certainly good programs. Schools and conferences are doing the same. So I think the more that we can shift focus to how we can support student athletes to make sure that they have an experience that is what they expect athletically, academically, socially, and that they're developing in all of those areas. I think, the more resources we can move in that direction, the better for the student athlete.
Yeah, you raise a good point. Because the additional flexibility and opportunity to take advantage of, name, image, likeness, kind of entrepreneurism, other things, do still cost time. And so, like, as much as these athletes are pressed on time between classes and their sport, to now not necessarily put an expectation on them, but like put this out there that they're going to probably feel social pressure to do because it's there, it's cool. They're seeing their other teammates do it. Okay, now do I have an extra 4 hours this week to go and shoot a video for something or to do this? Like, you're right. I mean, that's a piece that needs to be, addressed and paid attention to, and the mental health of the student athletes needs to be a focus. And not that you want to use that as an excuse to curb the opportunity, but you want to support them and recognize that there's a trade-off, make sure they recognize there's a trade-off, when it comes to their time. And that it's not just mailbox money for a lot of them. It's going to be work and time. And so, yeah, that's an important piece.
Yeah. I think recognizing, just educating, some of the pitfalls that come with being a social media influencer. There's so many of them now. And do you think that already there is a social expectation, especially when you're a young person, in the age that we typically see college athlete, college aged individuals, if we are to lump them all into one big group, I would hazard a guess that there's already a social expectation that's pretty significant to be producing some sort of content, whether that's social media or just, perfecting their brand or, whatever it is. That messaging is so ubiquitous that I think that pressure already exists. So the more that we just acknowledge and say, here are ways that we as schools can help you manage that, can only benefit.
Absolutely. Is there anything that we haven't touched on that we need to mention before signing off here? We've gone about an hour and covered a lot. Anything that you're really looking ahead to here in the next week or 10 days as we round this July 1st corner, or anything else coming up?
Yeah, well, I think certainly we'll have some interesting news out of Indianapolis, or remotely, I guess, as the D1 governance bodies continue to meet. I believe the board of directors is meeting perhaps in conjunction with another group today. So we may see some more news come out of Indianapolis today. And then certainly I think the targeted date for the council, D1 council, to vote on something related to NIL is Monday, as you mentioned. So I think, that's going to be probably the most instant as we head into July 1 and those NIL laws.
You did it.
I knew I would do it this once.
We couldn't make it more confusing for ourselves by just switching the letters. Ugh.
But yeah, so close. But I think, those will be kind of big things. And like you mentioned, other decisions that the Supreme Court handed down this week, the student free speech case, and how that's going to impact intercollegiate athletics and all the litigation that's, like I said, currently pending, especially I think keeping a close eye on that House v. NCAA case now that's in the district court in Judge Wilkins' district is, I think, possibly the next big step. And one thing I thought that was really interesting, and I won't, go into it because I know we're kind of short on time here, but I think one of the questions that's being raised in that case is, are we appropriately separating what is the labor market in college athletics versus, what is the consumer market when we talk about the application of antitrust law? We just got the Alston decision, and now I think we're going to maybe see some questions about whether that's the appropriate way to apply scrutiny if you're talking about two different markets here, labor versus consumer. So, it's a great time to brush up on antitrust.
Yes.
if you're in college athletics or interested in the business of college athletics. So, I think we'll continue to be in this tumultuous time for the foreseeable future as we deal with all of the COVID impacts that are still coming and will be long-term, including mental health issues related to that and student athletes, as well as physical health issues. So, we're not, I think the train is moving, to use the analogy, full speed ahead, and shows no sign of slowing down as it comes to interesting topics to talk about in the business of college sports.
Absolutely. Well, Stephanie, thanks for taking time out to visit. It's good to see you and catch up, and hope everybody listening to this whenever and wherever enjoyed the conversation, and would love to hear from anybody that wants to talk about these things. I'm on Twitter at Daniel Hare, or on LinkedIn, probably two easiest places to find me. I don't know, Steph, if you want to put anything out there for ways they can contact you, go for it.
Yeah, no, absolutely. You can find me on LinkedIn. I'm not as active on Twitter as I used to be, so LinkedIn is probably the best way to find me, Stephanie Grace, on there. So yeah, feel free to reach out with any questions, and I'm always up to chat this business. So I'll argue with you at length if you let me. I would enjoy interacting some more. So I appreciate you having me, Daniel. It was great to talk with you.
All right, my thanks again to Stephanie Grace for joining us on today's show. If you enjoyed this episode, would you do a couple of things for me? Would you subscribe so you don't miss an episode? And would you rate and review the podcast in Apple Podcasts or wherever you listen? And by the way, if you want to hear more sports law stuff, let me know that too, because we could either add more to this feed or maybe create a new podcast to talk about sports law, because it's a lot of fun. So if you have suggestions like that or any other thoughts, Daniel@varsitysearch.com. As well, if you are interested in looking at other opportunities, maybe a lateral move, or want to know what's going on in the market, would love to visit with you about that as well. All right, that's it for today's episode of Lone Star Lawyers. Thanks again so much to each of you for listening. I'm Daniel Hare with Varsity Search, and we'll talk with you next time.